unexpected events, and all of the evidence suggests that something extraordinary happened. Now, on the primary level, what is it that was extraordinary that happened? And the state have offered no evidence whatsoever in that regard. Then the secondary level. The secondary level is that this case was preceded by an inquest. It was a fully investigated docket. Mr. van Locherenberg's report was put up soon after the accident. There was an inquest where there were meetings of experts and a joint minute. The state knew exactly the challenge faced by them in trying to make out a case for culpable homicide. And not only that, we put in a plea explanation. Now, as you know, an accused person is not obliged to give an explanation of his plea, and that explanation of the plea is both what he knows himself and what he knows from consultation and expert evidence. And he describes, look, this would be my defense to a case that could be put up against me. And no effort was made to challenge that defense. No effort was made to show adequate draining on the highway. No evidence was put up to show that there was not pooling on that night. In fact, the evidence suggests the contrary. People, when they emerged from the combi vehicle, the taxi, after the accident, were ankle deep standing on the highway, that is on the left side of the highway. Every indication, therefore, that there was standing water on the highway. At every level of the challenge put up, the state have failed on the secondary level. Now, if I could turn to the heads of argument, and they start with the summary in paragraph 1, indicating that the accused pleaded not guilty. And then in the paragraph, we deal with the section 115 plea explanation, which is that it had been raining on that evening, at times moderately and at times heavily, and the road was wet. Soon after the Grayston off-ramp, his vehicle, Mr. Zuma's vehicle, hit a pool of water and he lost control of his vehicle. His vehicle, out of control, veered across the highway and struck something. It then spun and came to rest facing in a northerly direction. That which it made contact with was another vehicle, a minibus taxi containing a number of passengers. Mr. Zuma says the sole cause of the collision between his vehicle and the minibus taxi was the fact that the accused vehicle aquaplaned and or hydroplaned on the pool of water. The two concepts are the same. One comes from Latin, one comes from Greek. Due to the rainy conditions and the consequent reduced visibility, the accused did not see the pool of water. It was 10 in the evening. He didn't foresee, and he believed it could not reasonably be expected of him to have foreseen that there would be a pool of water on a national highway. Subsequent to that, independent investigations have indicated that the gradient or slope in the area in which the accused vehicle struck the pool of water is inadequate to handle the offlow of water from the road surface in that area, and consequently leads to a puddle or pool forming. Whatever caused the pooling of water, it was there and unforeseeably there. Although the accused did not know it at the time and could not reasonably have been expected to know this or foreseen this, the accused caused investigations to be undertaken as to the handling capabilities of Porsche 911, and it has now been established that that type of vehicle is prone to hydroplane or aquaplane more easily than other vehicles due to its lightweight, wide tires and positioning of the engine at the rear of the vehicle. The accused did not know this at the time, nor could he have been expected to know he was driving a vehicle which has a propensity, unlike other vehicles, to hydroplane or aquaplane. In fact, the research the accused has caused to be conducted now demonstrates that the manufacturers of Porsche 911 turbo vehicles have introduced a so-called wet mode in an attempt to counteract the design fault found retrospectively to exist, in particular in the Porsche 911 turbo that Mr. Zuma was driving. The state has called all its witnesses and closed its case, and we submit that it is plain that the state has failed to prove all of the elements of the charge and further failed to disprove the defense raised by the accused in his plea explanation. That is the primary and the secondary challenge. In other words, just taking the state's case, what did they prove? What negligence on the part of Mr. Zuma was established by the proved facts? None. They proved a collision. They proved a rainy night. They proved a dark, rainy night. They proved that something extraordinary happened. Two vehicles traveling in the same direction with two lanes in between them. Suddenly the one vehicle hits the other vehicle at the back. I'll put it just as vague as that. And they prove no explanation for that whatsoever, never mind the finger of culpability, the finger of blameworthiness for the accident pointed at Mr. Zuma. On the secondary level, we say, look, state, we've looked at this. There's a joint minute of experts. There is a design fault in the Porsche. There is this fault of aquaplaning. We put up to you the challenge of disproving that defense. We do not have a duty to prove our defense. The state have a duty primarily to prove its case at this level, a case that a reasonable court might convict on, acting carefully, and to disprove the defense raised. They have failed at both hurdles. Now, Section 174, Your Worship is well aware, provides that if at the close of the case for the prosecution at any trial, the court is of the opinion that there is no evidence that the accused committed the offence referred to in the charge or any offence of which he may be convicted on the charge, it may return a verdict of not guilty. And obviously there is an alternative charge of negligent driving that really falls away, because if negligence is made on the main count, it links then to the causation of death, it links therefore to culpable homicide. So we come back to, was Mr. Zuma driving negligently? And we say in paragraph 10 that it's well established that no evidence does not mean no evidence at all, but rather no evidence on which a reasonable court, acting carefully, might convict. It's more or less where I got to before we adjourned. And now let me continue. The question whether a court should grant a discharge at the stage of the proceedings is one which entails a discretion, that's your discretion, sir, by the trial court, being a discretion which must self-evidently be exercised judicially. Now, just to explain that, not so much to you, but to those who are listening, we have a discretion to have an ice cream or not have an ice cream, but that's not the kind of discretion we're talking about here. We're talking about a judicial discretion, and that means one exercised wisely with all the appropriate considerations taken into account and inappropriate considerations left out of account. There is a competence to do so, and the court is called upon to act judicially with sound judgment and in the interests of justice. The judicial pronouncements on the manner in which the trial court must exercise its discretion have over the years been contentious or dealt with, and we give you the Puravata case where the learned judge said the presumption in favour of innocence, the fact that the onus rests on the state, as well as the dictates of justice, in my view, will normally require an exercise of the discretion in Section 174 in favour of an accused person, where the state's case is virtually and basically non-existent. Strengthening or supplementation of a non-existent state case is a physical impossibility. Is not perhaps the best expression of the test, but what the court there was reaching for is that you cannot, as we could prior to 94 in some of the controversial cases, say to yourself, or the court says to itself, or the state says, but if the accused is called to testify, there's a likelihood that he will strengthen the state's case. That is unconstitutional and not part of our law. And which leads us to paragraph 12. Since the inception of our constitutional order, conflicting views have arisen as to whether or not the Constitution has impacted on the test to be applied by a court in an application in terms of Section 174. The decisions culminated in the Supreme Court of Appeal finally deciding the issue in Lubaksa, State versus Lubaksa, It may well be that it's a Xhosa name and therefore it's State versus Lubakba, but I'll call it Lubaksa. And the learned judges there said, I have no doubt that an accused person, whether or not he is represented, is entitled to be discharged at the close of the case for the prosecution if there's no possibility of a conviction other than if he enters the witness box and incriminates himself. The failure to discharge an accused in those circumstances, if necessary mero motu, that's on the part of the court without asking counsel what his view is in my view a breach of the rights that are guaranteed by the Constitution and will ordinarily vitiate a conviction based exclusively on the self-incriminatory evidence. Let me put that in context. If my learned friend from the prosecution is expecting to say, but if Mr. Zuma goes into the witness box, I'll be able to ask him what speed he was doing, why he never dropped his speed from this speed to that speed, all of the things which have not been proved in the trial, then it may be that from him I'll get an incriminating version. But that is not our law. The law is what has the state proved so far. And insofar as I haven't dealt with that yet, I will deal with it fully later. But going back to the dictum in Lubaksa, the right to be discharged at that stage of the trial does not necessarily arise, in my view, from considerations relating to the burden of proof or its concomitant, the presumption of innocence, or the right of silence, or the right not to testify, but arguably from a consideration that is of more general application. Clearly, a person ought not to be prosecuted in the absence of a minimum of evidence upon which he might be convicted, merely in the expectation that at some stage he might incriminate himself. That is recognized by the common law principle that there should be a reasonable and probable cause to believe that the accused is guilty of an offence before a prosecution is initiated, and the authorities quoted there. And the constitutional protection afforded to dignity and personal freedom, sections 10 and 11 of the Constitution, seem to reinforce it. It ought to follow that if a prosecution is not to be commenced without that minimum of evidence, so too should it cease when the evidence finally falls below that threshold. So if we shouldn't have been charged in the first place, but have been, and if the evidence fails at that first hurdle, that should be the end of something that should never have begun. And that is the case here. That will preeminently be so when the prosecution has exhausted the evidence and a conviction is no longer possible except by self-incrimination. A fair trial, in my view, would at that stage be stopped, for it threatens thereafter to infringe other constitutional rights protected by sections 10 and 12. Then we go to the Williamson J judgment a long time ago, I think it was 1984. The law was that accepting the state's case at face value, are you called upon to answer that? And Williamson J went further. He said, no, you can't do that. You have to look at the inherent value of the evidence in the first place and decide, never mind that the witness said X, did he sustainably say it? Because it's artificial to look at what a witness said if you're never going to believe that evidence, either on the probabilities or in relation to all the other evidence. So you have to look qualitatively, so said Williamson J. in the Mketa judgment, which is quoted in paragraph 13, where the learned judge held that the relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. But then, cutting to a more modern judgment, where Homo J, in the Agliotti case, well followed at the time, said the following: in State versus Lavengua, the view was expressed that the processes under Section 174 translate into a statutory granted capacity to depart discretionarily in certain specific and limited circumstances from the usual course, to cut off the tail of the superfluous process. Such a capacity does not detract from either the right to silence or the protection against self-incrimination. If an acquittal flows at the end of the state's case, the opportunity or need to present evidence by the defense falls away. If discharge is refused, the accused still has the choice whether to testify or not. There's no obligation on him to testify. Once this court rules that there's no prima facie case against the accused, there also cannot be any negative consequence as a result of the accused's silence in this context. I agree with the view that it is an exercise in futility to lay down rigid rules in advance of an infinite variety of factual situations which may or may not arise. It is thus my view also unwise to attempt to banish issues of credibility in the assessment of issues in terms of Section 1474, or to confine judicial discretion to musts or must-nots. So what was his lordship saying there? In our submission he was saying the following. On a case-by-case basis, you take a long view of the totality of the evidence put before you, and you look at it critically with regard to credibility, and you say, well, has the case been made? And if no case has been made, I can't say to myself, well, if I refuse a discharge, the accused might go into the witness box, and then he might give some evidence which could make the case that is now absent and build a case for the state. And I would submit that that's what the state hopes for in this case. So therefore, what we say in paragraph 15 is that the legal position regarding applications in terms of Section 174 is an accused person is entitled to be discharged at the close of the case for the prosecution if there is no possibility of conviction other than if he enters the witness box and incriminates himself. I'll analyze the evidence in a moment, Worship, but let me jump ahead of myself for a moment and say, take the evidence of Mr. Shlamini, Ms. Shlangise, Ms. Matron Ndakane, even Mr. Johan van Locherenberg, and the evidence of Mr. Cronje. Put it all together, take one step back, look at it and say, does that case make out a case of negligent driving against the driver of the Porsche? Where does that evidence show that he was negligent in the senses that the state have bound themselves to, those that I've reiterated from paragraph 4.2? And the answer to that question is no. Both at the primary level, what happened here? A bizarre accident? Yes. How did it happen? Who was culpable in not doing something, or doing something, or doing something wrongly, or not doing something correctly? There's no evidence. Then, in paragraph B of our summary, in deciding whether an accused person is entitled to be discharged at the close of the state's case, the court may take into account the credibility of state witnesses, even if only to a limited extent. And let me pause there. There was no difference between myself and Mr. Shlamini. He didn't see an accident, he felt a bump at the back. And then he describes what happened afterwards, including the vehicle leaning over and coming back. How it hits the steel barrier and damages which part of the vehicle, no one is entirely clear. Mr. van Locherenberg says he struggles to believe, he's not entirely sure that it can be said that the Porsche collided with the right rear of the vehicle quite high. He thinks he would have expected to see some scrape marks, but no, it's speculative. He uses the phrase, I don't really believe it, I struggle to believe it, but there's no groundwork showing at any level of conviction either that he's right or that it makes any difference. What we've got to go back to is what was the root cause of the collision, and he can't deal with that. In fact, I put to Mr. van Locherenberg the conclusion that was reached by Mr. Lotter and some of the reasoning, or basically the reasoning that goes to that conclusion. He said he cannot differ. I put to Mr. Shlamini how it happened. He says he cannot differ. I put to Matron Ndakane. She says she cannot differ, and she was a particularly poor witness. I don't know why she took the attitude that having answered Mr. Barber's questions, she could refuse to answer mine because I, quote unquote, wasn't there. So there's no credibility to attach to her evidence. She didn't know anything about speed. She's not a driver. Plus, you just can't rely on her. So Where is this evidence against Mr. Zuma that says he drove negligently? It's not there. The prosecutor can't say. But if Mr. Zuma goes into the witness box, I'll be able to ask him, but why didn't you slow down from 100 to 90 to 80 to 70? I don't know which speed the prosecution will choose as the right speed on that night to avoid aquaplaning, because they have not led any evidence. In fact, they've led evidence to the contrary. The witness himself, Van Lochrenberg, says you just don't know. And he and Mr. Strydom agree, and therefore the witness agrees, that you can't just slow down to an impermissibly low speed because of the likelihood of causing a different kind of collision by driving more slowly than the rest of the traffic. There's no evidence about what the rest of the traffic was around Mr. Zuma, either from any of the witnesses that were called. And we know that the taxi driver thought to drive at 90 to 100 was fine for him. Why would it not be fine for any other user of the road? And one knows that while you don't keep up with other speeding vehicles, there's a general tempo of traffic in rainy conditions or normal conditions which one keeps up with. If you don't, you cause yourself to be a danger. So where is the evidence that this bizarre accident, two vehicles traveling in the same direction at night in rainy conditions, that the driver of the Porsche failed in some way to do something? That challenge was the challenge at the primary level for the state to prove, and at the secondary level we said, look guys, this is what happened, disprove it, and they haven't. So then we come to paragraph C, where the evidence of the state witnesses implicating the accused is of such a poor quality that it cannot be safely relied upon, and there is accordingly no credible evidence on record upon which a court acting carefully may convict. An application for discharge should be granted. Now, on what evidence, of whatever quality, is it said by anyone that Mr. Zuma acted negligently? Given, of course, the concessions made by Mr. Van Lochrenberg that he cannot differ from the conclusion reached by Mr. Lotter, and that therefore that's also his opinion. So I struggle to find, either on the primary or secondary level, how there is a case which you're called upon to answer. Then paragraph 16 of our heads, in Agliotti, His Lordship Mr. Justice Gomo found himself bound to acquit the accused in terms of section 174, the end of the prosecution case, as the only witness who was expected by the prosecution to implicate the accused to the charges set out in the indictment had dismally failed to do so after his evidence was cancelled or negated in cross-examination. Now, I didn't really have a very difficult task in cross-examination. I was faced by witnesses who didn't know how it happened, who confirmed the rainy conditions, who confirmed the reduced visibility, who confirmed ankle-deep water on a national highway immediately after the accident, and therefore at the time of the accident, and no explanation by any of the witnesses as to how the accident happened. So even taking their evidence almost as uncross-examined, where is the case for negligence? And then importantly, you have the concession by Mr. Johan Conrier for Porsche as to what happened to him. Now you must remember Mr. Cronier was called with no advance notice to us to say that there's a Porsche management system, there's ABS braking, there's a traction control system, and therefore that this is a sophisticated vehicle where Mr. Zuma's driving would have been aided by advanced technology. But the difficulty with that is twofold. One, he said when a Porsche or any vehicle aquaplanes, because there's no contact between the tire and the road surface, none of those things are in operation. The car is sliding over a film of water compressed between the tire and the road, and there is no traction. With no traction, there is no steering. The evidence is that you will continue to go in one direction, unable to turn. Now, whether that direction is a swerve to the left because of an inclination of the tires in one way, or the wheels in one way, or whether what happened to Mr. Cronje, he says he was lucky. His wheels actually stayed straight, but he had no control over which direction he was going. So, Mr. van Lochrenberg's evidence must be understood in its context. If you're driving on a road and your wheels are dead straight, it's likely you'll go dead straight. If your wheels have, by the impact with the water, been pushed to the left or to the right, you will continue in that direction that the wheels have been pushed. So once you're in the slide, once you're in the aquaplane, you will have no control. The direction of that aquaplaning will be dictated by the circumstances. So there is no challenge in Mr. van Lochrenberg's evidence at any level whatsoever. And fundamentally, he doesn't differ from the propositions put to him by us on behalf of the defense. So where are we going in this case, Your Worship? Actually nowhere. In Dewani, paragraph 17 of our heads, also a very well publicized case, an excellent judgment by Her Ladyship, Miss Justice Traversa. In that case, the evidence of an accomplice on which the case of the state substantially rested was of such a poor quality that the court was unable to discern where the lies ended and the truth began. Traverso DJP maintained that the court should not, in those circumstances, cherry-pick certain parts of the evidence which can be accepted and others should be rejected, since reliable corroboration was required in such circumstances. Now, there's no accomplice in this case, but equally, what part of the evidence of whom makes the combination of jigsaw puzzle pieces that puts together a case we are called upon to meet? None. In Mojapela, paragraph 18 of our heads, Dulka, Judge of Appeal, found it to be astonishing that the trial court had not granted a discharge where there was no credible prima facie evidence implicating the accused, where the only evidence against them was the unreliable, uncorroborated and flawed testimony of, in that case, an accomplice whose evidence had been described by the trial court itself as nonsensical and bizarre. The point there is not that we've got an accomplice here, but it would be astonishing in our view that one could take the patchwork quilt of inconclusive evidence put forward by the state where they do not describe how the accident happened, what the cause of the accident was, what the negligence was in their evidence. And any argument as to the negligence of Mr. Zuma would be speculation and the hope that if Mr. Zuma goes into the witness box, cross-examination of him will get from him a falling from the standard of care that the state should have proved in their case. So in paragraph 19.1, we list the witnesses. These were the witnesses as at yesterday, but I'll add, Mr. Nxumalo was the weather expert. Why he was called, I don't know. All he could say was that the weather measured at a particular time, 10 o'clock on the night of the 1st of February 2014, was 1.6 millimeters. There was 4.8 millimeters earlier on in the 24-hour period. I think there were 14.8 millimeters. But he said that means absolutely nothing, because he agreed with me that you could be, for example, driving along, suddenly find yourself in very rainy conditions, and a kilometer later find yourself in clear skies again. The overwhelming evidence is that there was severe rain on that evening, that there was pooling on the highway, so said the witnesses when they got out of the motor car, over ankle deep. So Mr. Nxumalo, I don't know, I suppose he was called to show that there was only 1.6 millimeters at 10 o'clock in Alexandra. I would suggest that the state failed on the weather level by leading so poor a witness in order to show that if Alexandra showed only 1.6 mils and less earlier on, then 3.6 kilometers away at the on-ramp at Greyston, there couldn't have been a lot of water. So the state actually tried to disprove the facts which it subsequently proved by means of its own witnesses. Then Mr. Cronje, I won't repeat it, but in essence, called to show that we've got a management system, ABS braking, traction control, and Mr. Cronje says two things. None of those operate if you aquaplane. He's aquaplaned in his own car at 70 kilometers an hour. He was lucky because he just went straight. And yes, Porsche has got a defect, and they're now fixing it in the new model. And that defect is it swims. Where in the state's case at a primary or secondary level did they show any negligence on the part of Mr. Zuma in the driving of the vehicle? None. They're waiting to cross-examine him to see if they can't dig from him, a layperson, some kind of negligence in his own testimony. And that's unconstitutional. Now let's deal with the test for negligence as a form of criminal culpa, and I think I'll finish before the lunch adjournment. The famous case of Kruger versus Kutsia tells us, for purposes of liability, culpa arises if a diligens pater familias, that is a prudent, the reasonable man, in the position of the defendant, would foresee the reasonable possibility of his conduct injuring another in his personal property and causing him patrimonial loss. Let's just pause there. That's of course the civil description of negligence, but let's see. Would a reasonable man in the position of Mr. Zuma foresee reasonably the possibility of the way he drove injuring another person? Where is the evidence that that was present on this night? It's not there. And would take reasonable steps to guard against such occurrence. Well, Mr. van Lochrenberg says, well, you reduce your speed. The evidence is, Mr. van Lochrenberg concedes, they were both doing about 90. Because where they were found was indicative of them having traveled at the same speed. Another reasonable driver, Mr. Shlamini, says, well, he felt that that was a reasonable speed to be driving at. Why not for Mr. Zuma? So, what steps is it to be said that should have been taken by the driver of the Porsche to guard against the occurrence? Reduce your speed. From what to what, given what level of pooling unexpectedly present on the road? No one has an answer to that. And then the last leg must be that the defendant or the accused failed to take such steps. There isn't any evidence of that. So it's been constantly stated by the courts for some 50 years that the requirement in A2, which is would take reasonable steps to guard against such occurrence, is sometimes overlooked. Whether a reasonable man in the position of the person concerned will take any guarding steps at all, and if so, what steps would be reasonable, must always depend on the circumstances of each case. No hard and fast basis can be laid down. Hence the futility in general of seeking guidance from the facts and results of other cases. And we would ask, on the facts of this case, in the mouths of and in the total conspectus of the state's evidence, what is it that Mr. Zuma did wrong? When did he do it? Why were they steps that he should have taken or not taken? What did he do that caused this accident culpably to occur? There is no such evidence. The history of the matter, I think, is common knowledge. The accident happened, the docket investigation was done, the SPP in Randburg did not institute a prosecution, the DPP was asked to decide, the DPP didn't prosecute, there was an inquest, the inquest was held, evidence went back to the DPP, they refused to prosecute. and then all of a sudden there was a prosecution. That is the history of the matter. We say so not for any of these political interference reasons, but we say that there has been 3 times a great hesitation to even bring these charges. Why? Because of the very facts that I've put out before you. So to the extent that these heads don't deal with all of the witnesses, Ms. Nhlagise this morning took the matter no further. The goop sound, who knows what that means? It could as well have been the right-hand side of the vehicle hitting the barrier as it tipped and came back. And then Mr. van Lochrenberg, you cannot overlook the fact that in the beginning of the cross-examination, I put to him, look, a mechanical engineer expert in reconstruction on the basis of these findings reaches this conclusion. Can you differ? No, I cannot differ. After that, whatever he says cannot ever boil down to an adequate explanation or evidence that says this man driving on that night was culpable, was negligent in any way whatsoever. And we go back to the Aglaati, Dewani, and other cases and say, my learned friend can't say, but if Mr. Zuma goes into the witness box, then I will cross-examine him, and I will find what? That he should have reduced from 90 to 80 to 70. Well, we know the Porsche will aquaplane even at 70. Or I will show what? That which I haven't shown already, that there wasn't pooling on the road. The evidence shows there was pooling on the road. I will show that somehow he must have been able to control his vehicle while aquaplaning, when no one says you can control the direction of travel of a vehicle by aquaplaning. And primarily, he'd have to set out to make the case again in the defense case as to how this accident happened. And that's the primary level on which the state has failed in the first place. If you take the conspectus of all of the evidence individually or altogether, there is no explanation how this bizarre collision took place, let alone one rooted in culpable negligent driving by Mr. Zuma. And that is why, Your Worship, we would suggest that in the exercise of your discretion, you should give a discharge at the end of the state's case and acquit Mr. Zuma of the main count and the alternative count for that matter.
Yeah, maybe just before I'm done.
Yep.
Maybe just before you said that, I realized you made a lot of emphasis picking up on the evidence of this Lacan regarding the amount of water that was used.
Yeah.
In the same breath, Lacan also made that
Sure.
speeding.
Yeah.
He said Mr. Zuma's car was speeding.
Yes, but
So I'm saying to you now, if you come back to the authorities that we have prepared, in particular the case of Dewani, where Travis Brady PS then was maintained that court should not pick certain parts of evidence. What do you say?
what I say about Ms.
Take into the
What I say about Ms. Ndekane is, firstly, she spoke nothing of speed. And only right at her evidence on leading questions did she begin to speak about speed. But then she said she can't actually judge speed because she's not a driver. So therefore she cannot validly comment on the Porsche speeding. But much more importantly, I tried to cross-examine her on that. I tried to go into her very description, and she declined to be cross-examined on that. You cannot take her evidence at one moment where she says speeding and then say, well, she said it, if she declined to be cross-examined on it. We were here, the prosecutor, the interpreter was there. She was given time and time the opportunity answer the question. And the questions were your description of the car and the speeding. Why were you looking to the right at the time on 10 o'clock at night you're traveling forward? Why would you look to the right and behind you? And that was part of the cross-examination on speeding. And she said, Honourable Man, I don't agree. I'm not answering the questions. So Your Worship simply can't take it into account. It would be wrong. If the prosecution tries to rely on it, they would be wrong. That evidence was not cross-examined because the witness refused to be cross-examined. So it's not there. Thank you.
Thank you, Your Worship. Would the court like me to proceed or should we adjourn for lunch? Fine, Your Worship, I am ready to proceed.
Rise.
We should have ordered lunch from that place.
Yes, Bushi.
On Trains Travel, we bring you a full guide on all things lifestyle related. With so much to discover, we give you comprehensive reviews of places to visit, music, travel, and food. We also explore the arts, whether on or off stage. All this and more, be sure to tune into Trains Travel Saturdays at 5:30 p.m.
When you put 5 girls against 5 guys, of course it's going to be lit.
Andile, what's the next challenge?
Witness all the fun, tension and laughs as we see how well friends know each other to win a luxury cruise. Join us as we bring the excitement every weekend at 6 p.m. only on SABC 1, Mzansi for sure.
Get the facts first.
In 1994, ek dink was ons almal was ook baie excited geweest.
For South Africa, art was never a good thing.
From a footballing point of view, there was never a separation.
Get to the truth.
There's still some serious issues in South Africa.
Maar ek dink die regering kan regtig waar probeer om harder te werk om
See what it all really means.
Ek is geel, want dit is die kleur in die verkeerslig wat vir jou sê wees versigtig.
I still give South Africa red.
We are somewhere in between.
We're giving our democracy a green for sure. We're very happy.
Democracy Gauge, weekdays at 5:30 on SABC News, Channel 404.
Like a shooting star, I go. Like a shooting star, I go.
Phambili weendaba zosaziwayo ukhona to turn that frown upside down.
We'll agree that the best way to spread a story is to include more people.
Get obsessed with the best of the best when it comes to Umkosi. Catch RGB Saturdays at 7:30 only on SABC 1 Mzansi for sure.
The sheer human misery, its devastation and fury, lives swept away in a wink.
It's very difficult. Some of the rooms that we visited had children who could not find their parents, and we cannot find the parents for them. You know, at UNICEF, we try to pair and reunite children and families, but we have put out the calls for the parents, and there's no response, so we fear the worst. So it is just a very difficult time in Barrow. We need assistance. South Africa has been extremely strong, sending help from the government to this government because the air assets, the planes that have been able to help in Barrow have been crucial for their assistance.
Cyclone Idai cuts a swathe of destruction across 3 SADC countries, Mozambique, Zimbabwe and Malawi.
We were sleeping with my 3 children and the house collapsed on us.
and my 8-year-old child was killed. We managed to escape to the kitchen, which also collapsed on us again and killed my 4-year-old child.
Watch African Perspective for the latest news updates on Wednesday, 9:30 p.m. Central African Time on SABC News.
Mr. Fako Musi out in Pretoria, of course, at the Public Investment Corporation inquiry, of course, which continues to happen. Nompu.
Duduzane Zuma is applying to have his culpable homicide case dropped. For more on this story, we cross to our reporter, Criselda Lewis.